Greetings, 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 greetings. I'm King Clifford Jefferson, descendant of Godfrey the fifth Caravan Jew, son of folk, ruler of Jerusalem. I'm the reincarnation of King Edgar the Peaceful, which we know as the Vicar of Christ or Melchizedek or the King of Righteousness. It is July 7th, 2025, which is equivalent to the birth year 2975. I greet you in the name of my mother, who had made the transition yesterday. I'll get your name of the ancestors who she's being received into the arms, as well as all those predecessors, heirs, and successors who are kindred to her. This is a beautiful lesson today. It's called Trust Law, and I will deliver as promised. Once again, today this lecture is called Trust Law, and I will deliver on that promise. Okay? A lot of us claim to understand trust law, but don't have a clue about what trust law is. The word trust law is exactly what it says. Trust the law. Okay? Trust law means trust the law. You can look at it in a concrete way or in an abstract way. Okay? Trust the law. 1 second. Okay? We look at the word trust law, it means exactly what it means. What does it mean to trust? Okay? What does it mean to trust? Let's look at that definition real quick before we go any further. All right. What does it actually mean to trust? All right. It has abstract, concrete, legal ramification, as well as everyday language. I mean, it could apply in anything. When we say trust law, okay, it's very important to understand exactly what trust law means from a legal perspective, not from a relationship or a feeling, but from a legal perspective. Hold that thought. Trust law is a legal relationship in which the owner of property or any transferable right gives it to another to manage and use solely for the benefit of a designated person. That's the definition of trust law. Okay? Very important. So when we trust in the law, it's do the law that we trust in that wherever is conveyed in the trust will be lawfully conveyed, okay, delivered to, okay? We understand that when you're involved in the trust, you might call it a cess tu quo, all right? It involves a grantor, it involves the fiduciary person who receives the trust, all right, on behalf of the grantor, and then you have the beneficiary, okay? So it's very important to understand that there are other terms that we can use as well, settlor or trustee, depending upon what um, uh, jurisdiction that you're applying the term trust. When you use trust in what we call contract law, trust can be a conveyance from one person to another, all right, and it could be anything, okay? A lot of people misunderstand the origin of trust law, especially in regards to property, because we talk about property, you got several types of property. You got estates, and then you got real estates, you got movable property, and you got non-movable property. Very important to understand that. In the English common law, the party who entrusts the property is known as a settlor. The party to whom is entrusted is known as the trustee. The party for whose benefit the property is entrusted is known as the beneficiary. Okay? That's very important. So, as the beneficiary, you are trusting, based upon the law, that the trustee is going to administer the estate as established by the settlor or the truster. Okay? Very important. All right? Very important. And the trusted property is known as the corpus or trust property. Okay? Corpus or trust property. A testamentary trust is an irrevocable trust established and funded pursuant to the terms of a deceased person's will. An inter vires trust is also a trust created during a settlor's life. Now, we understand that when a person is incapacitated, that means that he's unable to administer the trust. So he sets one over the trust, which you call a power of an attorney. Okay? You either have a power of an attorney, you either have a trustee, or you can have the chancellor, okay? Or you can have the attorney general. All these things we're going to talk about in regards to trust law. Hold that thought. Hold this thought right quick. All right. I need you all to pay very close attention. So we're talking about, all right, yeah, I already had it up here. So trust law. Let's go to the origin. History. English common law. All right. English common law. The origin of trust. Roman law had a well-developed concept of trust and in terms of testamentary trust. That means one created by will, which is in writing, all right, but never developed the concept of intravenous living trust, which applies while the creator lives. So if the creator left a trust, then that creator must be in fact living. That creator is the grantor or the truster, okay? Very important. This was created by later common law jurisdictions. Personal trust law developed in England at the time of what? The Crusades. All right. We're not talking about your Bible. All right. We're talking about the time from the 10th century on to the 13th century. Okay. I'm going to go to the 11th century to the 13th century. Okay, they're saying 12. I'm going through the 11th century because it all goes back down to the Plantagenet and the Frankish kings who were intermarried, as well as Spanish kings. And in medieval English trust law, the seller was known as a fiefur to uses, while the trustee was known as the feoffee to uses, and the beneficiary was known as the cestui use or the cestui trust. All right, very important that you write these terms down. They are applied to the origin from where the term originated from, not what somebody else wanted to say it came from. All right? Very important because it all involves property. At the time, land ownership in England was based on feudal system. Okay? When you're talking about the feudal system, you're talking about the parliamentary system that was subject to what we call the Curia Regis. Okay? All right, which then evolved to what we call the Privy Council, which involved to the Privy Council. When a landowner left England to fight in the Crusade, we're talking about actual events, he conveyed ownership of his land in the absence to manage the estate and pay and receive feudal duties on the understanding that the ownership would be conveyed back on his return. This is a vassal. This is a knight. Okay? However, Crusaders often encountered refusal to hand over the property upon their return. English common law did not recognize a crusader's claim. As far as the king's courts were concerned, the land belonged to the trustees. Okay? Very important. Who was under no obligation to return it. The crusaders had no legal claim. The disgruntled crusaders would then petition the king. All right? A petition is done by way of what we call a writ, a prerogative writ. Okay? Very, very important. The disgruntled crusaders would then petition the king, who would refer to the matter to his Lord Chancellor. Okay? Everybody write that term down. Lord Chancellor. Okay? We're going to connect the dots. The Lord Chancellor. Okay? When we're talking about the Lord Chancellor, you're talking about the keeper of the king's consciousness. That's what the Lord Chancellor is. The keeper of the king's consciousness, or the conscientious law, which you call natural law. Conscientious law, which you call natural law. The Lord Chancellor could decide a case according to his conscientiousness. All right? Consciousness. I just said that. Conscientious law or natural law. At this time, the principle of equity was born in English law. However, the original notion of equity goes all the way back under the presumption to Aristotle and is found in Book 5, Chapter 10 of his Ethics. Indeed, the universities of the 13th century often wrote commentaries on Aristotle's work, and it was these universities that gave rise to lawyers at that particular time. We don't know, we don't need to go back to that time because we understand time immemorial goes back to 1189. Okay? 1189. Let's continue and let's stay on course. The Lord Chancellor, write that term down, would consider it unconscionable that the legal owner could go back on his word and deny the claims of Crusader, the true owner. Therefore, he will find in favor of the returning Crusader, Over time, it became known that the Lord Chancellor courts, the courts of chancery, okay, the Lord Chancellor Court or the Court of Chancery would continually recognize claims of returning crusaders. My brothers and sisters, you are the crusaders. You've been fighting a crusade all your life. You were born into this crusade. The legal owners would hold the land for the benefit of the original owner and would be compelled to convey it back to him when requested. Who was the legal owner as a result of the crusade? The devil. Who was the one who was on the crusade? God's children. When God's children returned from the crusade, the devil would have to return it. This was the law governing the law governing equity. Okay? Very important. Equity means equality. The crusader was the beneficiary and the acquaintance the trustee. The term use of land was coined in a time developed into what we now know as a trust. Okay? Trust law. Trust in the law. Laws are governed by trust. Okay? Laws are governed by trust. This is very, very, very important to understand that. I'm going to go right here and read this last part. Significance. The trust is widely considered to be the most innovative contribution of English legal system. Today, trust plays a significant role in most common law systems, and their success has led to some civil law jurisdictions to incorporate trust into their civil codes. In Curaçao, for example, the trust was enacted into law on January 1st, 2012. However, the Curaçao Civil Code only allows express trust constituted by notarial instrument. This is called your public notary or your notary republic. You don't need an attorney. You don't need a county clerk office. You don't need a judge. All you need is a notary. Even though you have a notarized in regards to those able to authorize what's it called? Uh, on the New Jersey statutes governed under Title 46 uh, Title 46 4, what is it? 46 New Jersey revised statute 46 4-21 and 46 4-6.1, 2.1 and 6.1. These are ones who authorize to acknowledge a instrument and those who are authorized to authenticate it. Okay, this is what the notary does when you have an instrument conveying property. Very important. Notarial, a notarial instrument. Let's just define that real quick. An act is an instrument that records a fact of something that has been said, done, or agreed. All right, what we got? Yeah. An act generally takes the form of a legal instrument or writing that has a probative value and an executory force. They are usually accepted as self-authenticated demonstrative evidence in court proceedings. So a notarial instrument, meaning something that's notarized, can be used as prima facie evidence upon the face of the instrument. That does not mean that the instrument is in fact valid. That's a matter left up for the Chancery Court, i.e., the Lord Chancery, i.e., the one who was put there by what we call the king. Very important. Let's move forward. So trust law. Trust law is also associated with equity law. Let's look at equity law real quick. Equity law. All right? Write these terms down. If you haven't, you can't go to the House of Awakening Minds and learn it. You can't go to the Canaan Land Moors and know this. You can't go to Sarwan Seti and learn this. You can't go to what's his name? What's the other brother's name? Not Sarwan Seti, but his name is Sarah. What's his name? Whatever his name is, and any other one of them. They cannot explain equity, equality, okay, from a legal perspective based upon your right to an inheritance under the laws that define the inheritance and the laws that protect the inheritance for the inheritors, and that will in fact be the beneficiaries. In order for you to be a beneficiary, you must have those acting on behalf of the so-called Setsuke, called a trustee, under the authority as conveyed by the grantor or the trustor or the settler. Very important to understand these terms because they are, in fact, interchangeable. In the field of jurisprudence, equity is the particular body of law developed in the English courts of chancery with the general purpose of providing legal remedies for cases wherein the common law is inflexible and cannot fairly resolve the disputed legal matter. We know common law means stare decisis. We know stare decisis means cases decided by judges. Okay, so this is why Chancery was instituted by Lord Chancellor, who can decide the matter on behalf of the argument brought by a party by way of what we call a petition. A petition is what we call a writ. A writ is a prerogative that the king has allowed his subjects to be able to seek remedy, to seek due process, whatever that due process was. If this makes sense to anyone that's listening out there in TV land, give me a thumbs up in the chat line when you make yourself known on the chat line. Conceptually, equity was part of the historical origin of the system of the common law of England. Yet it is a field of law separate from common law because equity has its own unique rules and principles and was administered by courts of equity. Okay? Courts of equity. Let's go to the origin of courts of equity. We don't go back to Aristotle because we're not Roman. Okay? Let's go back to equity in common law jurisdictions in general. And jurisdiction following the English common law system, which goes back to Henry II, son of Godfrey, the fifth Count of Anjou, son of Fulk, ruler of Jerusalem, which the crusade was all about. Okay, equity is the body of law which developed in the English courts of chancery and which is now administered concurrently with the common law. English courts of chancery are called prerogative courts. English courts of chancery are called prerogative courts, okay? In common law jurisdiction, the word equity is not synonymous for general fairness or natural judgment, but refers to a particular body of rules that originate in a special system of courts. What special system of courts? Let's look at it. For many of the history, the English common law was principally developed and administered in the central roll courts, the courts of the King's Bench, the courts of common pleas, the courts of exchequer, the courts of Star Chamber, the courts of Chancery, under the Judiciary Act of 1870, which effected a procedural fusion of the two bodies of law, ended their institutional separation. If everyone understands that, please make yourself known. The reform did not fuse the actual bodies of law, however. As an example, the lack of fusion meant it was still not possible to receive an actual remedy for a purely common law wrong. Judicial or academic reason which assumes the contrary has been described as fusion fallacy. Everyone needs to understand that. Fusion fallacies. All right, let's go to the origin. If they have it right here. Listen, y'all. I'm not just talking, I'm showing you. All right. It's like giving the narrative, but I'm able to bear witness to the narrative based upon somebody else, a third party. Okay, because a third party cannot qualify like I'm qualifying it. Okay. After the Norman conquest of England, very important, we had a government or a parliament of law called Witan or Witema, which means the King's Council. That changed to what we call the Career Regis, which changed to what we call the Privy Council. Okay, all concerning equity, chancery, under the authority of the Lord Chancellor, who was put there by what? The King. After Norman conquest of England in the 11th century, royal justice came to be administered in three central courts: the courts of the King's Bench, the courts of common pleas, and the exchequer. The common law developed in these royal courts, which were created by the authority of who? The King of England. Everyone understands that? The King of England, and whose jurisdiction over disputes between the king subject was based upon what? A prerogative writ. Initially, a writ was probably a vague order to do right by the plaintiff. It was usually a writ of grace issued at the pleasure of the king or the chancellor or the attorney general. Those were the only ones authorized to use the prerogative that's reserved for the crown. We're going to prove this by common law. During the 12th and 13th century, writ procedures gradually evolved to something much more rigid. Our writs to commence action had to be purchased by litigants from the chancery, the head which was the Lord Chancellor. I repeat, during the 12th and 13th century, writs procedural gradually evolved into something much more rigid. Our writs to commence action had to be purchased by litigants from the chancery. You had to purchase a writ from the chancery, and the head of that was what? The Lord Chancellor. That's the only way he had a chance. After writs began to become more specific and creative in terms of relief sought, Parliament responded in 1258 by providing the provision of Oxford that the Chancellor could no longer create new writs without permission from who? The King, as the King's Council of the Career Regis. And we know that goes back to who? William the Conqueror. Okay? William the Conqueror. Anybody is up to speed with what I'm talking about, please make yourself known. Now we're going into what we call charitable trust. Okay? Matter of fact, let's hit Court of Chancery. Let's look for that before we go to charitable trust. Court of Chancery. Court of Chancery was an court of equity in England and Wales that followed a set of loose rules to avoid slow-paced changes and possible harshness of any inequity in the common law. The Chancery had jurisdiction over all matters of equity, including trust, land law, estates of lunatics, and the guardianship of infants. This deals with the term parens patriae, father of the nation, father of the country. Is either the king, or the attorney general. Okay, and the king appoints the attorney general. Somehow they have lost sight of that. Its initial role, dealing with the Court of Chancery under the authority of the Lord Chancellor, different in somewhat, as the extension of the Lord Chancellor role as keeper of the king's consciences. The court was an administrative body primarily concerned with what? Conscientious law, which you call natural law. Okay? Natural law. So if you don't understand English law, common law, then 9 times out of 10, the law that you practicing is not natural law. Okay? Very, very, very important. And if it's not natural law, then that means that you're not conscious, okay, or not conscientious about the law. Because if you were, you would be, as the Lord Chancellor was, as everyone else should be, based upon allegiance, the keeper of the king's consciousness. What is the keeper of the king's consciousness? What is that? Let's look up that real quick. Keeper of the king's consciousness. Keeper of the king's consciousness. Keeper of the king's consciousness was a position in the English judiciary. Very important. Not the Attorney General, but the English judiciary, i.e., the Lord Chancellor, before the event of parliamentary representative democracy. The person appointed as keeper of the king's conscience was usually a bishop or a priest, because a priest is a bishop. He was responsible for overseeing the international affairs of the monarchy and for delivering justice on behalf of the king. So the keeper of the king's consciousness was the Lord Chancellor, and the Lord Chancellor was a high priest or a bishop. He was responsible for overseeing international and national affairs of the king. Today, the position has become Lord Chancellor during the period beginning with William the Conqueror to Henry VIII of England. And the person holding the keeper of the king's conscience post also held high positions in the church. Did you hear that? So you must be a part of the church. Very important. Why? Because now we're going into charitable trust, because we know charity has to do with charitable trust. Okay? Very important. What is charity? Let's define that. Charity refers to three things. All right? Charitable organization, or charity, a nonprofit organization whose primary objective are philanthropy and social well-being of persons. So that means this must be a corporation or an organization. What else? And whatever nonprofit. These things deal with charity, okay, as well as the religious society. Then we have what we call the actions of charity, which is the practice of being benevolent, giving, and sharing. Okay, and then you got the religious aspect of charity, whether you're an organization or a corporation or not. It's based upon Christian values, the Christian religious concept of unlimited love and kindness. Okay, it's very important to understand the three concepts of charity: the practice of it, the virtues of it, and how it's being administered. Okay, you can't make money off it. You can't be out there giving people stuff and selling it. Okay, it has to be based upon goodwill towards men. All right. Very important to understand that, for you to understand where I'm going with it next, because now we come into what we call a charitable trust. What is a charitable trust? Let's look at that term. It's also associated with wills, trusts, and estates. Okay? Has everything to do with what it is that we as the people were supposed to be doing. A charitable trust is an irrevocable trust established for only charitable persons, i.e., dealing with charity. In some jurisdictions, it is more specific term in a more specific term than charitable organization. A charitable trust enjoys various degrees of what? Tax benefits in most countries, and also generate goodwill. Some important terminology in charitable trust includes the term corpus, Latin for the word or the term or the meaning body, referring to the assets which the trust is funded, and the term donor, which is the person donating the assets to the charity, which means that that will be the grantor, that will be the truster who established the estate trust, or the trust that's in the state or whatever estate that was in the form of a trust. Okay, it's very important because it all is subject to what we call trust law. It's heard by courts of equity, which is Chancery Court, and the one to oversee that is the Lord Chancellor. And 9 times out of 10, any trust that's associated with an estate that overseen by the Lord Chancellor is a part of the estate of the king. That's what we call crown land. I hope everyone understands this terminology. But now we go into what we call, let's go a little further. All right. Several circumstances render such trusts invalid. Charitable trusts are prohibited from operating for profit, and their purpose cannot be non-charitable unless these purposes are ancillary to the charitable goal. Furthermore, it is deemed unacceptable for charitable trusts to engage in campaign for political or legal change. However, discussing political issues in a neutral manner is permissible. Charitable trusts, like other trusts, are administered by trustees, but there is no direct relationship between the trustees and the beneficiaries. This results in two key points. Listen, y'all. First, the trustees of a charitable trust have greater freedom to act than other trustees. And secondly, beneficiaries cannot take legal action against trustees. Beneficiaries cannot take legal action and trustees. That's a very important to understand that you make sure that you got the right trustee. You make sure you got the right attorney, power of attorney. To make sure you got the right judge or the right chancellor or Lord Chancellor. Because if you don't, you in the world a problem. Why? Because all this goes back to Provence Patriarch. Instead, the beneficiaries are represented by who? The Attorney General for England and Wales in their capacity as Provence Patriarch, appearing on behalf of the Crown. Once again, the beneficiary represented by the Attorney General for England and Wales in their capacity as Provence Patriarch are appearing on behalf of the Crown. That's very important because a lot of our brothers and sisters, aunts, uncles, mothers and fathers, grandmothers, grandfathers, etc., all that their ancestors had in the state that they had intact before they even came upon the scene as a result of the Crown. Because the crown was the father of the nation. The crown was Provence Patriarch. The crown appointed the Attorney General to act on behalf of the crown, which is the extension of Lord Chancellor of the Chancery Court. All right, very important because you're going to read these terms in case law. I know I speak quickly, but it's the truth. Let's continue. Provence Patriarch. Okay. So now we know Chancery Courts, where you're talking about the Exchequer, Star Chamber, Courts of Common Pleas, Courts of Chancery. These are what you call prerogative courts. All right? They are called prerogative courts. We must understand the language. All right? What is the prerogative court? A prerogative court is a court through which discretionary power, privileges, and legal immunities reserved to the sovereign were exercised. In England, in the 17th century, a class developed between these courts, representing the crown's authority. Whose authority? One said the crown's authority. Nobody has the authority but the crown, and the crown is personified by the king, and the king appoints the Lord Chancellor or the attorney, whichever, and they act on behalf of the authority of prerogatives and the common law courts. Prerogative courts include the Court of Exchequer, the Court of Chancery, Court of Star Chamber. These procedures were flexible and not limited by common law procedures. The Star Chamber became a tool for King Charles, the Scottish king, employed against his enemy and was abolished by the habeas corpus at 1614 by Parliament. A parallel system also existed under the common law court, which was grounded in what A1 said, the Magna Carta under property law. The main common law courts were the courts of the King's Bench and the courts of common pleas. We must understand the lingo. Okay? With that being said, let's go here. Chancellor and equity. Let's get a little religious significance to it. Okay. From Ghana Law Hub, they got more knowledge about law than all of majority of United States American citizens, for that matter. All right. This is um a Berber, all right, from Ghana. We know Ghana was founded by Berbers, okay? Ashanti, all these tribes that originated in West Africa, all right? All of these were Berbers, okay? A part of what we call the Ghana Empire. Ghana is a modern name, very important. It goes back to the richest kings in Ghana, which were all nobles, okay? These were all part of the profession, okay? Advocates of law, very important. The Chancellor in Equity, epitome of Christ and the grace. This is by Justice Alexander Osei Tutu of the Supreme Court of Ghana, okay? Once again, by Justice Alexander Osei Tutu from the Supreme Court of Ghana. Let's look at the Supreme Court of Ghana. Supreme Court of Ghana is under the jurisdiction of the Privy Council of London, United Kingdom. Okay? We'll look at that in a second. Everyone get this article. The Chancellor and Equity. Now, with the understanding we already have about the Chancellor and Equity, which are synonymous because one is the action and one is the one who acts upon the actions as established by the law. The Lord Chancellor deals with matters in equity as established by the Chancery Court as initiated by the kings of England. Very, very, very important. But somehow, Justice Alexander Osei Tutu, all right, from the Supreme Court of Ghana, has correlated this with the scriptures. Okay, so let's see if we can get some understanding and connection that Christ was in fact an advocate for charity. Okay, he was in fact a member of the bar. Okay, he was in fact a part of a nonprofit organization. Okay, we must understand the history of our Lord and Savior. I said, there is no profession that I know which perfectly illustrates Christ's redemptive work better than the legal profession. In this article, we will look at the striking similarities and parallels that exist between Christ's ministry and the legal profession. Maybe you did not know that Christ was a lawyer when he was on earth. Question to all of you. Did you know that Christ was in fact a lawyer when he was on earth? Or if he ever comes on earth, he's going to be a lawyer. Okay? That's what the scriptures prophesied about. So if you're looking for somebody as that Christ figure, he better know the law. Okay? He was an advocate. Remember how he defended the woman caught in adultery in John chapter 8? Okay? This is very important. Advocates as a noun is a person who represents another person's interest like a lawyer does. This is a bona fide lawyer, pro bono. Okay? He don't get paid for it. The word was derived from the courtroom. It is from the Latin advocare, to add a voice. To advocate means to add a voice or support to a cause or person. Okay? We must understand the connection. Okay? So when your Savior come back, you know who he is, because it said, my sheep will hear me by my voice. Okay? So if you are the sheep of the shepherd, then you must understand the voice of the shepherd, because the shepherd advocates on behalf of the sheep. When the wolf comes for the sheep, he advocates by what? Protection, by upholding the law to what? Protect. What department in the government does the protection? The judiciary system. All right? We must understand this connection. As members of the bar, Christ feels comfortable, pardon self, As members of the bar, Christ feels comfortable dealing with his colleagues. Okay? At least I am aware that when he had an encounter with Paul, who was his bar colleague, they instantly clicked, even far better than the original apostles who were chosen from other professions and had been with Christ for some time. The partnership of the legal brains, i.e., Christ and Paul, won them many soul cases of international repute Gentiles, possibly more than what the apostles all won for Christ. Indeed, Christ continues to play the role of an advocate as we speak. John gave his clue when writing his first epistle to the church in this manner. If anyone sins, we have an advocate with the Father, Jesus Christ, the righteous. John 1 John, 1 John, second verse, second chapter, first verse. I am told that Christ now been elevated to the bench by the Most High and is getting ready to judge all mankind. Okay, watch where this is going. This is from a Supreme Court judge of Ghana. All right, who 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 was appointed on behalf of a parliament system that was instituted by United Kingdom. Okay, very important. All right, and they follow the parliamentary procedures of the Caribbean regions. All right, this is why when there's any matter that Supreme Court cannot deal with, they're not the appellate court. It's the Privy Council which acts as appellate court to matters that are not resolved with the Supreme Court of Ghana. All right, very important. I am told that Christ has now been elevated to the bench by the Most High and is getting ready to judge all mankind. A medical doctor, Luke, wrote in Theophilus to disclose this new appointment and the cases awaiting him. This is how Dr. Luke conveyed the message. He, God, has appointed a day on which he will judge the world in righteousness by the man whom he has ordained. He has given assurance of this to all by raising him from the dead. Acts 17, verse 31. Chapter 17, verse 31. John clarified that God has even left all the cases to be tried on the judgment day to our bar colleagues. For the Father judges no one, but has committed all judgment to the Son. Due to the special love for his professional colleagues, he does not want any member of the bar to be found guilty on this day. So he has gone to the extent of using development of equity to convey his grace message clearly to use. So we know that judges are members of the bar. And we know under the common law, which is not the law of equity, is different. Okay? So we must understand that when Jesus came to exemplify the law, he wanted to make sure that his members, his colleagues, his members of his council were all in line with the law. Okay? Very important because Jesus' ministry was charity. Okay? And ministers to the poor, helping the sick, being advocates for people. How many of us are doing that right now where we need to be doing it? Due to the special love for his professional colleague, he does not want any member of the bar to be found guilty on that day. So he has gone to the extent of using development of equity to convey his grace message clearly to us. Sometimes the idea that God means God the Father, God the Son, and God the Holy Spirit makes no sense. Similarly, Article 11.2 of the 1992 Constitution may make no sense to a layperson. According to Article, the common law of Ghana shall comprise 1. The rule generally known as the common law, the rule generally known as the doctrine of equity, and 3. The rules of the customary laws. For a layperson, how can common law mean common law, correct equity, and customary law? Question. For the mathematician, it is like X equals X and Y and Z. For God to make us understand the possibilities of the divine Trinity, he gave us the Trinity of the common law of Ghana, speaking for that nation of people. In the Bible, the Old Testament represents the era of God the Father. The New Testament had God the Son. In our dispensation, has God the Holy Spirit work. Let me read that again. In the Bible, the Old Testament represents the era of God the Father. The New Testament has God the Son, and our dispensation has God the Holy Spirit at work. And it began with the Word was God, the Word became flesh and dwelt amongst man. And an analogy of the common law in the Old Testament. All right. Before we continue to read further, let's look at the person giving his dissent, because this is the judge. Okay. This is the judge based upon his legal and lawful understanding of the common law and his association with the scriptures. Okay. Very important. Let me give you an image of the brother. Everyone see him? This is the writer of this article. Look what he's holding up in his hand. The Holy Bible. Okay? He's holding up the Holy Bible. The Holy Bible was written by King James because he's sitting in the council of British Parliament. Okay? And British Parliament descended down from British tenures that were held by Scottish kings. Okay? So this is how he understands the biblical relationship to law as God ordained it. Okay? We must understand that he's holding up a Bible. Okay? Very, very important. All right? Everyone see that. So let's look at the analogy of the common law. If he found the analogy in this article from him, let's see the analogy that he's talking about. All right, let's look at the analogy. The common law was embedded in traditions, customs, and uses, and not in codes as found in most civil law jurisdictions. God originally put his law in the hearts of men. In the Garden of Eden or in the Abrahamic era, there was no written law. Listen, y'all. There was no written law. Man's disobedience to the external law brought about positive law and the giving of the 10 Commandments. Let's qualify that. Okay? Let's qualify that. Supreme Court of Ghana. Supreme Court of Ghana is the highest judicial body in Ghana. Ghana's 1992 constitution guarantees the independence and separation of the judiciary from the legislative and executive arms of the government. History. The Supreme Court was established by the Supreme Court Ordinance of 1876 at the highest tribunal in the Gold Coast, now called Ghana, during the colonial era. Okay? During the colonial era until 1960, there was a right of appeal to the Judicial Committee of the Privy Council in London, England. Okay? So the Supreme Court of Ghana, it was a court that had their matters appealable, and the Privy Council of London, England, that was created in 1960. Okay, so what is the Privy Council? Let's look at that. Judicial Committee of the Privy Council. Let's look at that. We go through everything here. History of the origin of the Judicial Committee of the Privy Council can be traced back to the Kure Regis or the Royal Council. Did everyone hear that? So we're talking about the Kure Regis way in Ghana. The Kure Regis is way up in Ghana. Okay? Kure Regis was founded by William the Conqueror. Okay? Very important. The origin of the Judicial Committee of the Privy Council can be traced back to the Kure Regis or a royal council. In theory, the king was the fountain of justice, and petitions for redress of wrongs arising from his courts were addressed to him. That power was gradually taken over by Parliament, which evolved out of the Kure Regis within England, but the King's Council, which also evolved out of the Kure Regis, retained jurisdiction to hear petitions from the King's non-English possessions, such as Channel Islands and later on from England colonies. Did y'all hear that? Did you hear that? So the Judicial Committee of the Privy Council evolved from the Kure Regis. All right? That's very important. Let's go back to Supreme Court of Ghana. So we know that the Supreme Court of Ghana was established and goes all the way back to the Privy Council that was descended from the Kure Regis. The Kure Regis descended down from William the Conqueror when he invaded England. This is the most paramount. This is most paramount because let's go back to the article written by the Supreme Court judge. All right, because they said they had an unwritten law. Okay, they said they had an unwritten law. The children in the Garden of Eden. Okay, they said they had an unwritten law before the written law was handed down. Okay, I didn't say that. That's what the Supreme Court judge said. The common law was embedded in traditions, customs, and usages, and not in codes as found in most civil law jurisdictions. God originally put his law in the hearts of men in the Garden of Eden or in the Abrahamic era. There was no written law. We know what it means by no written law, meaning that it wasn't written down. Man's disobedience to the eternal law brought about positive law and the giving of the Ten Commandments. We know positive law is what we call administrative law. Originally, application of the common law was only in England. It had no application in Ghana. Similarly, the Old Testament was applicable to only Jews in Israel due to the covenant God had with Abraham and Jacob. It had no application in Ghana. So once again, we see that they had an unwritten law versus a written law. This is very important because we said that the Supreme Court of Ghana got their authority from the Privy Council of the United Kingdom. Okay, and it said that the United Kingdom law descended down from the Kure Regis. So let's look at the Kure Regis, which was the written law. Okay, let's look at the Kure Regis. Quriaregis. Touch on that real quick. He had a. I understand that. Good to see you, Mr. Sapphire. You're right. King James never wrote the Bible, but he had the Bible written in English. King James took it from other translations. We go back to William Tyndale and a whole bunch of other people. For the sake of the lesson, I won't have time to discuss that, but you're absolutely right. He didn't write the Bible, but nonetheless, King James is written in the Bible. Okay, and we know that King James took his right to be called king under what we call the divine right of king, and that's associated with the coronation ceremonial, which we talked about last time. Okay, good to see you. So we see that the Ghana under the Privy Council was derived from the Kure Regis, which was initiated by the Norman Conquest in 1066 by William the Conqueror. Prior to that, they didn't have any written law. Okay, we must understand that. Let's look at the Norman Conquest real quick. If you have any questions Mr. Sapphire, please ask them. Right here. Career Regis. All right, so we're going back in time. After the Norman conquest, still talking about the Career Regis, which was preceded by the Privy Council, all right, which are other modern parliaments, including North America's parliamentary cabinet, descended down from. It said after the Norman conquest of 1066, the central governing body of the Kingdom of England was called the Career Regis or the Career Domus Regis, Court of the Lord King. You hear that? Court of the Lord King before the conquest. The Anglo-Saxon called this body the Witan. That's great to hear that. Before the conquest, the Anglo-Saxon called this body a Witan. The English writers continue to use the term as well. It corresponded to the Placitum Generale of the Frankish kingdoms, and this name was also applied to the English Career Regis. It was similar to, but not the same as, the Career Duces, which served the Dukes of Normandy. Members, and particularly the king's household knights, were also known as Caerularius Reges. Okay, so we see that the Career Regis was the predecessor for what we call the Privy Council. All right, we know that the predecessor for the Career Regis was called Wittemont. Now we know when we go to Wittemont, let's look at that real quick before I go on back to the article. Wittemont. Witan, or Wiseman, was the king's council, the Anglo-Saxon government of England, from before the 7th century until the 11th century. It comprised important noblemen, including aldermen, thanes, and bishops. Meetings of the Witans were sometimes called Wittemont. As you can see in the exhibit here, it says Anglo-Saxon king with his Witan, biblical scene illustrated in the Old Hexator, which means the 5 books of the Bible, portraying Pharaoh in the court session after passing judgment on his chief baker and the chief cupbearer. It says, and the primary function was to advise the king on legislation, judicial cases, land transfer, and other matters of national importance. This goes back into what we call the chancellor or the Lord Chancellor. The Witan may have elected new kings from among members of the ruling dynasty after the Norman conquest in 1066. These roles were performed by a similar council known as the Career Regis. But we want to go back before the Career Regis. We want to go back before the laws were written down. In order to do that, we must go back and see what they say in the 1911 Encyclopedia Britannica about the government of Witan, which was created by the Wise Council, i.e. Witan, which means like Wise Council. The 1911 Encyclopedia Britannica expounds upon that. Okay, 1911 Encyclopedia Britannica expounds upon that. Okay, in light of what we just said, now we know that the Magna Carta was a written document, okay, forced by the royal barons or the feudal baron versus the English barons. So we see here, it says this fact has been emphasized by Dr. R.G. Latham, who writes, and we ain't talking about England, we're not talking about Europe, we're talking about North Africa, okay? We're talking about North Africa, the same continent that Ghana is on, okay? The Ghana on. We understand that Ghana, as established by Chief Justice of Alexander Tusu, he's in the article we're reading about, he's talking about chancellor, chancery, equity, all right? He's speaking about these terms that he learned while being educated in the history of the common law of England. But getting a dumbed down or a watered down version of the government, because we're from William Blackstone, he was illiterate in the common law of England, as well as Edward Coke, based upon true origin of where the common law stemmed from, which is totally different from what we call the laws of equity or the laws of chancery, which is a court where you definitely have a chance at. So it says, in our quote, this fact has been emphasized by Dr. R.G. Latham, who writes, all that is in Arabic in the Kingdom of Morocco, All that is not Arabic in the French province of Algeria. All that is not Arabic in Tunis, Tripoli, and Fezzan is Berber. The explanation lies in the profound distinction of their character. The Arab is a herdsman and a nomad. The Berber is an agriculturist and a townsman. The Arab has built his social structure on the Quran, which inculcates absolutism, aristocracy, and theocracy. The Berber, despite his nominal Mohammedanism, is a democratic with his Jimna or Wittenma and his Kanun or unwritten code, the Magna Carta of the individual liberties as opposed to the community's good. So when we go back to the article as written by Tusu, Supreme Court Judge Tusu, let's go back there. Because we know the Berbers go back to the Neolithic times. Let's go back to there. The common law was embedded in traditions, customs, and usage, and not in codes as found in most civil law jurisdictions. God originally put his law in the heart of men in the Garden of Eden or in the Abrahamic era. There was no written law. Man's disobedience to the eternal law brought about positive law in the giving of the Ten Commandments. We know that Alfred the Great incorporated the Mosaic codes into the laws when he brought all the tribes together during the barbarian kingdoms unification once they broke away from Charlemagne, the Frankish Nordic king. 2, original application of the common law was only in England and had no application in Ghana. Similarly, the Old Testament was applicable to only Jews in Israel and Israel due to the covenant of God had with the Abraham and Jacob. It had no application in Ghana. Genesis 28. Let's read a little further. The use of writs, forms, and commission actions. A person can only initiate an action by buying the appropriate writ forms from writ shops. We just read that. Okay? We just read that. The use of writ forms and commission actions. A person can only initiate an action by buying the appropriate writ form from the writ shop. In the Old Testament, one needed to perform the prerequisite rites of purification in order to attract God's forgiveness or presence. No new writ forms were to be introduced from the 13th century. God shut the door to the people from having other gods besides him. The God of Israel is one in Deuteronomy 6 and 4. God is a jealous God and was not prepared to share his glory with any other. They were to continue obeying God's commandments and statutes and live strictly by them. This is very, very important because we go into what we call, let's go here. Let's go right here. Deuteronomy 17. Since it mentioned Deuteronomy, let's go to Deuteronomy, the last book in the Bible. All right? They call it the 5 books of the Bible. We call it the Hexapla. That goes to the history of Elphick of Inshon. Law courts. All right? So this is a commandment from God about seeking due process of law in the courts that he go to. Mind you, let's go back to the picture. Let's go back to the picture. All right. Deuteronomy 17, 8 through 14. Let's read what it says. All right. For the prophecy, it said, if cases come before the courts, and we already read that Jesus was an advocate, all right? He was a member of the bar. He was with his colleagues. He was defending based upon why his ministry was established, and that's based upon charity, okay? Defending the poor, defending the unsound, okay? This is the purpose of charity, okay? This is the purpose of almshouses, okay? This is the purpose of charitable organization. This is the purpose of public housing, okay? To be able to house uh, the discouraged, the injured, those who were left out, left to the wolves. Okay, this was the purpose intent of charity that the Lord, the Creator, intended. Okay, all right. No one goes to the court and seek what the Lord told you to seek in court, okay, based upon the Lord's instructions to the children of Israel, because we're talking about the children of Israel. It said, if cases come before your courts that are too difficult for you to judge, whether bloodshed, lawsuits, or assaults, take them to the place your Lord, your God will choose. And if your courtroom got the Bible, that's where you should be going. Go to your biblical priest and to the judges who is in the office at that time. Because if Jesus was able to do it, he said, take up your cross and bear it as well. Inquire of them, and they will give you their verdict. We know a verdict is the ruling or the dissent under the judge's decision. You must act according to that decision they give you at the place of the Lord will choose. Be careful to do everything they instruct you to do. 11. Act according to whatever they teach you and the decisions they give you. Do not turn aside from what they tell you to the right or to the left. Anyone who shows contempt for the judge or for the priest who stands minister there to the Lord your God is to be put to death. This is why when we read the article, it says that Jesus didn't want his members of the bar to be found guilty in the sight of the law. Okay? You must purge the evil from Israel. All the people will hear and be afraid and will not be contemptuous again, based upon the law and based upon the one who revealed the law to those who don't know the law, governing trust. Because Jesus had a trust placed upon him. Okay? He was the conveyor of the trust by the grantor, which was his father. Okay? Very, very, very important to understand that. All right? Let's see. The king. When you enter to the land your God is giving you and has taken possession of it and settle in it, and you say, let us set a king over us like all other nations around us. Be sure to appoint over you a king the Lord your God chooses. This is what we call the right of kings. All kings choose their right to, all people or all nations choose who they want to be their king or their head of state, etc. All right. But this one was chosen by God. Why? Because he didn't go by what they said or the laws they said. They went by the laws that God stated based upon the law that was there. And that was a law written upon their hearts. Okay. He said, he must be from amongst your fellow Israelites. Do not place a foreigner over you, one who is not an Israelite. The king, moreover, must not acquire great numbers of horses for himself or make the people return to Egypt to get more of them. For the Lord has told you, you are not to go back that way again. He must not take many wives, or his heart will be led astray. He must not accumulate large amounts of silver and gold. Why am I saying that? Let's go back to the article written by the judge. He makes it clear. We're on 5. 5. Stare-dices judicial precedents. The Old Testament accounts are there for our guidance in the strengthening of our faith. So the statutes or the scriptures are considered stare-dices, okay? Precedents, based upon the language of those who declare what the law should be as you receive it, based upon the abstract stories written in the Bible versus the concrete stories that are written in the law. Okay, so as I always see, he who writes your books sets your timeline. God was the settler. Once again, we're talking about trust law. Okay, we're talking about equity. We're talking about chancery, the court that deals with conveyance of property, proving who owns the property, who the property belongs to. That is the job for the Lord Chancellor. It says, God was the settler or the truster who created the earth for man as beneficiary to dominate and control. Genesis 1, verse 26. However, when Adam sinned, the authority, i.e., the title deed, passed unto the devil as the trustee. I'm going to read that again. God was the settler, okay? All right. Right now, ain't no beneficiaries on the land right now. God was the settler. All right. God already had in mind who was going to inherit the land. Okay. I don't want to read it in no Bible. I don't want to read it in no scrolls. I want to read this verse in the law. Show me in the law where I can fully understand, because the judge had a Bible in his hand. And apparently we're reading it and he's coinciding the two based upon Lord Chancellor, Chancery, which is the court that proves how inheritance are supposed to be conveyed, returned through remandment, reversion, etc. So it says God was the settler, and we know the settler is the truster is the grantor who created the earth with the instrument for man as the beneficiary to dominate and control. However, when Adam sinned, when man sinned, the authority, i.e., the title deed, passed unto the devil as the trustee. We know what a trustee is, right? One who oversees the trust. He don't own it, he just oversees it. So man lost his authority of controlling the earth to the devil based upon a title deed. And we know a title deed is not proof of ownership, my brothers and sisters. It's only proof of possession. Okay? When you got a deed, you can create a deed based upon adverse possession, based upon you taking something that don't belong to you. The devil took the land. Why? Because the trustees were not properly overseen, and he put new trustees in place of it. Okay? How we know that? Let's look at it. Lottery of Caesar. There's only two ways: lottery of season and lottery of law. Word lottery is synonymous with delivery. Lottery indeed, whereby the parties met together on the land and transferred, symbolically delivering the possession of the land by handing over a twig or a clump of earth to the recipient, versus lottery of law. Lottery of law, whereby the parties went within sight of the land and the transferor declared to the recipient that the possessors was to be given, followed by the recipient entering onto the land. The symbol of it was a key, door rasp, a mill, clap, or hopper. Okay? Church, a psalms book, key, and so on and so on. Whatever proof of the conveyance that validated from the grant to the grantee was the evidence. In this case, will be the deed. All right. Lottery of deed, lottery of law. That's very important because we see that process as read in the article. Once again, the process of lottery of season was right here. God was the settler who created the earth for man as a beneficiary to dominate and control. Okay? So when God created the land, he created benefits, he created trustees to oversee the estate for the beneficiary, who right now is a minor. Okay? So we had somebody to oversee the estate until that minor came of age. This is what you call what's the term? Escheatment. Okay, this is the concept of the crown. Okay, until that person comes of age, it's left in a trust. You call it a cess to que. So when God settled the land and created the earth, this was called lottery of season by lottery of law, not by lottery of deed, because in order for the deed to be created, it must be both parties, the conveyor and the grantee. Okay, and it must have it notarized in acknowledgement that the conveyance was valid. Okay, and then have it recorded in the county recorder's office. All right, that process does not involve lottery of law. Lottery of law is when the grantor say, look, you go over there, you take possession of that and you do the process that was established by the law. The same law we read in Deuteronomy 17, 8 to 14. Okay? Court, and when the king come back to convey the land, how to go to the court proceeding, and receive due process of law, all the way up to the chain, all the way up the chain. If you don't get in the lower court, you get in the higher court. The highest court is the Supreme Court, and we're going to use that because we're going to use their narrative. Okay? So it says, so man lost his authority of controlling the earth to the devil by way of a deed, a title deed. Okay? Very, very important for you to understand that. With that in mind, let's go here. Charitable trust. Matter of fact, let's go here. Charitable trust in England. I ain't really touched on nothing right now. I'm about to get into it right now. Charitable trusts in English law are forms of express trust dedicated to charitable goals. Okay? Very important. For charitable goals, so it means it's for non-profit. There are various advantages to charitable trust status, including exemption from most forms of tax and freedom for the trustees not founded in other types of English trust. So if you're not a trustee of an English, then you are an unlawful trustee. Okay? You are an unlawful trustee. I'm not saying it. They're going to say it. Let's look at it. Let's go to the origin. Charity. So we're talking about trust law, charity, charitable trust, charitable organization. All these terms are very important. All right, because now we're going back to trust law. Okay, we're going back to trust law. No, not trust law, almshouses. That's what I want to go to. Charitable organizations. All right. A charitable organization or charity is an organization whose primary objective are philanthropy and social well-being, educational, religious, or other activities serving for the public interest or common good, which is a non-profit organization. The English Third Temple Church of England is a non-profit organization. It's a church. It's a religious society. It's also a polity. Okay? Let's go to the history. All right? Until the mid 18th century, charity was mainly distributed through religious structure, such as English poor laws of 1601, almshouses, and bequests from the rich. Christianity, Judaism, and Islam incorporated significant charitable elements from their very beginning. Almsgiving has a long tradition in Hinduism, Jainism, Buddhism, and Sikhism. Charity providing education, health, housing, and even prisons. Almshouses were established throughout Europe in the early Middle Ages to provide a place of residence for the poor, old, and distressed people. King Alfred of England reigned from 924 to 939, founded the first record almshouse in Europe in the 10th century. Okay? King Alfred, an Anglo-Saxon Berber, established the first charity, the first public housing, acting as parens patriae for those who were not protected by the nation. We must understand that. How we know that? Because he established a process called lottery of season. Okay? So he understood that when his descendants come into their age from the Crusades, okay, that the true owners of the land will be able to understand law and able to seek due process in a court of law where remedy can be sought. Okay? Very important through the process that we read through Deuteronomy 17, 8 to 14. Okay? We see that lottery of law, which was established by Ashleton, which was a customary ceremonial method that we use to convey land. Okay? Let's go back there. Lottery of season. Who created it? What was the ceremony? Friggin' turf ceremony. All right? William Penn used the ceremony, all right, to make claims to land, and it backfired. Okay? See New Jersey versus Pennsylvania. All right? It backfired because he didn't have the right. He violated the statutes of usage. He violated the statutes of frauds. Why? Because he did not follow the statutory law that's in place to this present day. All right? What is the twig and turf ceremony? He couldn't use it. Why? Because he was not an Anglo-Saxon descendant. Look, who would say? The lucky newcomer commoner goes to the given acre, all right, and cuts out a turf from the selected site and drops 2 shillings and the whole made. The high steward of the county, shire, hundred, whatever you want to call it, then twitches him with a twig and sticks the twig in the turf, all right? Then hands it to him, saying, "This twig and turf I give to thee, as free as Ashleton gave to me. And I hope a loving brother thou wilt be." The high steward then takes the money out of the hole, and the new landowner replaces the turf. That is the ceremonial practice of lottery of season from a king to an heir. Okay? If the heir does not come of age, then it automatically cedes to the crown. It's called inquisition post-mortem. That is the concept of the crown, my brothers and sisters. Okay? That is the concept of crown. We see the same legislative enactment passed at the time of, in the Middle Ages, right here in the legislative of 2024. Let's read it for ourselves. Mr. Sapphire, is this information convincing? Statutes of Uses. This was passed by Henry VIII from the House of Tudors in a 2024 statute in New Jersey. Every person to whom use or uses of any real estate within the state which have been sold, given, limited, granted, released, conveyed by deed. Remember, the devil took it by title deed. God didn't give it to you by deed. He gave it to you by law. Okay, very important. A law that wasn't even written down. That meant that his law was communicated from him to you. This is when you get into the preamble. We the people and God Almighty preserve from generations to come. Okay, that's the communication between God's nation, God's people, which God clearly understood because they spoke the same language. Okay, when you go to what we call, we spoke about it, people deal with a common mass of people that are from the same ethnicity or nation. Okay, so it says, every person whom use or use of any real estate within the state which has been sold, given, limited, granted, released, or conveyed by a deed, grant, or any other legal conveyance whatsoever, or that shall hereafter be granted by any deed or conveyance whatsoever, and his heirs and assignees shall be held to be in as full ample possession of such real estate to all intent, constructions, and purposes as if such person, his heirs or assignees were possessed thereof by sovereign what? Library of season and possession, and any usage of custom to the contrary is not withstanding. Do everyone understand what that just said? That meant that if you don't have an instrument conveyed to you by way of library of deed or library of law, going back to the ancient ceremonial of library of season, going back to the kings, then it's not your right to have it. All right? Very, very important. Let's go back to the article. Matter of fact, let's go here. Let's actually look at a video from the Supreme Court Judge of Ghana, Justice Alex O.C. Tuti. Now, they're limited in their understanding of law. All right, I'm more advanced in law than they are. Just look at it. Whoever's listening, please let me know if you can hear the video.
Changed, transformed, and many people are losing out because they have not paid attention yet. Let's get ready. Get your loins. So here we are, and I want us to begin right away by getting into a very interesting subject to raise. You say this thing about power of attorneys. Is it invalid if the person who attested to it is not present in the country where the power of attorney was made?
Thank you, Samson. Exactly so. It does appear that in practice, you see a litigant outside the country who would want to litigate, and his lawyer will prepare a power of attorney for him, quickly send it. After signing, he sends it back to the country, and they get somebody to witness for the person. Me as a judge, immediately I look at the document, especially sometimes you see the document being commissioned by a commissioner for it. Once I see that, the first question I ask myself, you are domiciled in, let's say, the United States, and the document is being commissioned in Ghana. So the judge will be curious to know how it happened. And fortunately for us, it has been decided by our courts that the one who is witnessing should be present at the time the document is being signed. So it's an area I would want the lawyers to look at it carefully so that their cases do not they do not lose their cases on technical grounds. So it's very necessary that the one who witnesses the power of attorney is present. If the person, let's say, is domiciled in UK and the witness is in Ghana, then there should be evidence that the person came to Ghana to execute it. Maybe he traveled, he came for Christmas, Easter, or any holiday, and executed it here. In that case, the passport and other documents, yes, should have to be shown or tendered in court to convince the judge that the document was actually executed in Ghana and the witness was present when it was being executed.
And I'm bringing you here so that you are not lost. There are many lawyers who got to know that we're going to do this show and were so much in a hurry to join. But you will not be lost in this discussion. It is important because there are many times when you have a relative, you have friends, you have associates who live outside the country, and there are circumstances in which they have to take up a suit in Ghana to defend a situation they need to protect. And they want to appoint you as the one represent them in court or to take the suit.
Power of attorney, parens patriae. That's what he's talking about.
Home looks like from space. Enter your address and get a 360-degree satellite view of your home.
He's talking about parens patriae, power of attorney, or the attorney general.
In the courtroom. How do you go about it? That is one of the issues we are talking about. What, for the ordinary person, what's the power of attorney? Which are the circumstances where it may be required?
Y'all listen. He's going to talk about property.
It's a document which is given to another person to perform a legal act on the person's behalf. You may be outside the country and would want to buy a property, and because you cannot be in Ghana to sign the document yourself, you may appoint a power of attorney. You may be outside the country and you may have somebody is trespassing on your land. You may want to take the person to court. In that case also, you may want to appoint a power of attorney for another person who is called Donnie to do that on your behalf. You can even be in the country and be busy or maybe disabled. You are incapacitated, maybe due to old age or your physical condition. You can still give a power of attorney to another person to do that lawful act on your behalf.
Okay,
So
all right.
basically, power of attorney is a document.
All right, so let's just start right there. Power of attorney, somebody acting on your behalf, whatever the circumstances may be. We have to go a little bit further than that because he's talking about power of attorney in regards to property, okay? Somebody acting on behalf, so that means they're acting as a trustee on behalf of the beneficiary based upon a conveyance that was promised by the conveyor or the trustor or the settler. That's what he's talking about. But yet we just read an article by this same Supreme Court judge, and he said that these was a result of the devil taking the land, okay? Title deeds. The devil took the land by deed. A deed is a written instrument, so if you got a written instrument, that means that you got your land from the devil. Versus lottery of season, when God told you how to receive your land, and that's what by lottery of law, going back to the ancient ceremony as prescribed by statute. It's called operation of law. He just told you that the devil took it. Let's go back here. He said, God was the settler who created the earth for man as a beneficiary to dominate and control. However, when Adam sinned, the authority, i.e. the title deed, you hear that? The authority was the title deed. The title deed is a result of you writing it up and having it filed for safekeeping just in case someone attests your claim, okay? But lottery of law, no one can attest it. You don't even need witnesses. Why? Because it was done from the original grantor, okay? That's called lottery of season, okay? So it says that the title deed passed unto the devil as the trustee. So man lost his authority of controlling the earth to the devil, okay? So if you get any land on earth that's called earth, guess who you getting it from? The devil. Because what? You got a title deed. Let's look up county recorders just to prove it. Hell, Frederick Douglass told us this. County. County recorders office. Bear with me. Let's prove that you're getting your land from the devil. Recorder of deeds. I don't care where you at, Africa, Europe, Spain. If you're not following the customary practices of land conveyance, now time out of 10, you're getting your land from the devil. Recorder of deeds. Listen to what it says. If y'all competent, and if you have an instrument called a deed in your possession, you do not own your property. All right? The difference between estates of land and real estate, totally different. Let's look at it. Recorder of deeds or deeds registry is a government office tasked with maintaining public records and documents, especially records relating to real estate ownership that provides persons other than the owner of property with real rights over that property. Did you hear that? Does that make sense, Brother McGarrell? Does that make sense, Sister Sapphire? Did you understand that? Please say yes or no in the chat line. According to the definition of recorder of deeds or deed registry, which is a title deed, is a government office tasked with maintaining public records and documents, especially recording related to real estate ownership that provides other persons other than the actual owner of the property with rights over that property. That's called an easement. That's called an easement. Let's pull that up since we're on the topic. I'm waiting for some response. Come by, respond to me. What about you, Miss Sapphire? You understand? You said you had tough skin. Let me see that tough skin you got. Easement. Easement. An easement is a non-possessory right to use or enter onto real property of another without actually possessing it. It is best typified as the right way in which one landowner A may enjoy over the land another B. An easement is a property right and a typical type of incorporeal property in itself at common law in most jurisdictions. So there's only three ways you can own land: life estates, defeasible, and fee simple. Fee simple. So it's right there. Recorder of deeds only record deed instruments of conveyances other than that are in possession of a person other than the actual owner. All right. Very, very, very important. All right. Now let's go here. Since we're talking about charity, okay? Very important. Since we're talking about charity, since we're talking about parens patriae, you know what I'm saying? Let's look at that real quick. Parens patriae. Did you leave, Miss Sapphire? You still with us? Parens patriae is Latin for father of the nation, father of one's country, and law refers to the public policy power of the state to intervene against an abuse or negligent parent, legal guardian, or informal caretaker, and to act as the parent of any child, individual, or animal who is in need of protection. Okay? Prince Patriarch, father of the nation. That's what that means. Okay? So a father of the nation is either the monarch, the sovereign, or the so-called president. All right? Those are the fathers of the nations or heads of states. All right? Or sheik, whatever term they use in any nation, those are the ones who are called parents of the nations. Okay? Their obligation is to provide charity for their subjects or citizens. All right? Very important to understand that as we go here. In Ray versus Bailey. Read this case law real quick. In Ray Baby M, 1987 case, New Jersey Superior Court Appellate Division. Okay? New Jersey. This is 1987, so it's every bit applicable. Okay? Now, we know Prince Patriarch means father of the nation, and the father of the nation is responsible for setting up equity for his subjects in regards to addressing their concerns when they have a problem with an estate, property, children, a will, etc. This is what that middleman is for. Okay? It says probably the most important authority of the court, and in the case law, from Justice Supreme Court, he was calling power of attorneys. Okay, he was calling them power of attorneys. That was a term used to usurp the power of attorney, which was actually Prince Patriarch, the father of the nation, which is actually the king or the crown. I'm not going to say it; they're going to say it. In regards to overseeing the poor, the children, the bastards, the bastardly, even the incompetent, okay? Whether you're 2 years old, whether you're 100 years old, all right? Someone has to look over your estate. Who is doing the job? I'm going to show you. Probably the most important authority of the court in the exercise of its parental jurisdiction. Jurisdiction is a word of broad and comprehensive impact. It means the authority by which courts, i.e. judiciary, and judicial officers take cognizance in deciding cases. It means the authority to act, to find, define, and apply the law. Did everyone hear that? Prince Patriarch is the power of the sovereign. You hear that? Prerogative, of course, is the power of the sovereign. Okay? The power of writs is the power of the sovereign. Prince Patriarch is the power of the sovereign in the case of the state of New Jersey by its judicial branch to watch over the interests of those who are incapable of protecting themselves. Okay? Very important. Let's look at that real quick. All right? We already looked up. Let's go here. Prerogative courts. Prerogative courts is the court through which discretionary powers, privileges, legal immunities reserved to the sovereign were executed. Did you hear that? Were executed. So we're only talking about the sovereign. In this case, will be the Magna Carta. Okay? Now we're going to go to case law to validate the sovereign. I mean, not case law, statutory law to validate the prerogatives of the sovereign, which were incorporated in New Jersey revised statutes, which are called reception statutes. 2024. Statutes became effective before September 15, 1948. This is the 1947 Constitution, became effective September 15, 1948. Any statutes become effective prior to September 15, 1948, it still remains in effect and which contains any provision governing or relating to any court or officer existing prior to that said date in accordance with the Constitution of 1844 hereinafter designated shall be given effect on and after said date as governing or relating to the court or officer established in accordance with the Constitution of 1947. Hereinafter designated as though the reference therein to the former court officer were made to such latter court or officers, except as otherwise provided in this act or in the rules made and promulgated by the Supreme Court in cases in which the provision of the Constitution of 1947 may be to the contrary, then the power conferred upon the jurisdiction vested in duty provided to be performed by the limitations prescribed upon the actions of or in provisions governing or related to, and any said former court or officer shall accept as aforesaid be conferred upon by vested in the performed by be applicable to or govern or relate to such latter court officers as fully as those such latter court officer was specifically referred to therein. So that means that it was applicable then, it's applicable now. All right, how we know it. Now we're talking about vice chancellors, masters, lord chancellors, etc., and prerogative courts where the Lord Chancellor sits. Okay, let's see it. C. Where the reference is to the Court of Chancery, it should be given effect as though it was the Chancery Division of Superior Court or judge of the Superior Court assigned, now called the Chancery Division thereof. All right? We know under the 1947 Constitution, it went from the Chancery Court to the Chancery Division. D. When the reference is to the prerogative courts and respect to its appellate jurisdiction, it should be given effect as though it were to the appellate division of the Superior Court, and otherwise as though it were to the Chancery Division of the Superior Court or a judge of the Superior Court assigned to the Chancery Division thereof. So all these laws, all these jurisdictions in regards to the court, jurisdictions that the court has, are still applicable today. Right here, F. Where the reference is to the chancellor as acting in or constituting the Court of Chancery, it should be given effect as though it were the Chancery Division of the Superior Court or to a judge of the Superior Court assigned to the Chancery Division thereof, and otherwise as though it were the Chief Justice of the Supreme Court established by the Constitution of 1947. Okay? So there's the validation in regards to the prerogative courts, not just the prerogative court, but as well as to the prerogatives. Okay, we know prerogative court is the court for the sovereign, and the only prerogative that the sovereign practices is what you call writs. And we know, as we read, based upon Chief Justice Tutsu, he said that when the devil took over the land, no more writs were issued. Okay. Statutes concerning references to proceedings under former prerogative writs. Okay? This is not present common law. This is a statute. Where any such statute contains a reference to any proceeding under the former prerogative writs, the reference should be given effect on or after September 15, 1948, as though it were to the proceeding in lieu of the prerogative writs provided for by the rules made and promulgated by who? By the Supreme Court. Okay? So we know prerogative writs belong to prerogative courts, and prerogative courts or the courts of chancery, the courts of exchequer, the courts of Star Chamber, the courts of common pleas. These are the courts or the courts of the King's Bench. All right? These are the ones that we were referring to when we read these legislative parliamentary reception statutes that are actually statutes of the crown. Okay? We must understand that. Let's go here now. Barwick versus Barbara. Okay? Barwick versus Barbara. This is dealing with infants. Okay? It's a shame how unconscious our people are. I mean, if this is boring to people, then I hate to see what they call exciting. The conception of equity inherited original jurisdiction as part of its general jurisdiction over the person, estates of infants has general exceptions. So we're talking about the estates of infants, lunatics, people of sound mind, and just people who just don't give a damn. Okay? While this jurisdiction may, and its very exception, have belonged to the king as part of his executive power as Providence Patriarch to protect his subject, it may by him have been transferred to the courts of chancery. Okay? It is firmly established as judicial function of the court. It does not belong to the chancellor alone as the personal delegate and representative of the crown. It is exercised by all judges composing of the Court of Chancery in the same manner and governed by the same regulation as all others confessedly judicial functions. Did you hear that? Did you hear that, my brothers and sisters? Palmer Royal Equity Jurisprudence, 5th edition, section 1304. It has been suggested that by the ordinance of March 28, 1770, the governor of the province of New Jersey was left with all the jurisdiction held by the English chancellor as a judicial officer as distinguished from his power as a minister of the king. You hear this? This is 1951. This case is applicable as it was then, as it is today. And it says, the province of New Jersey was left with all the jurisdiction held by the English chancellor as a judicial officer as distinguished from his power as a minister of the king, or representing the king as Providence Patriarch. And that original jurisdiction of the Court of Chancery did not include the care or property of infants, a subject which belonged to the chancellor in England as Providence Patriarch rather than as a court, and was conferred upon the chancellor of New Jersey by what? Statute. Okay? Not common law, but statute. It says, but be that as it may, it was long recognized that the old courts of chancery had general jurisdiction over the care and custody of infants domiciled or actually residing in New Jersey. Chancery had a beneficent prerogative of care and protection of infants because of their incapacity for self-protection due to their tender years. All right? Most of y'all are still children. Chancellor Stevenson found that the control of infants was part of the original general jurisdiction of the Court of Chancery, and that while, of course, laws in regards to infants may be made and changed from time to time, the jurisdiction of the Court of Chancery to enforce those laws cannot be impaired by legislative enactment. The jurisdiction of the state to regulate the custody of infants found within this territory does not depend upon the domicile of the parent. It has its origin and its protection that is due to the incompetent or helpless, due to the incompetent or helpless. For this reason, the residence of a child suffices though the domicile be elsewhere. At common law, an illegitimate is deemed newly affiliated with a few rights or privileges. He has no inheritable blood, but he has the right of property. He can have no heirs except of his own body, and if he left no lineal descent, his property is what? Exceeded. We know what exceeded means, back to the crown. This is very, very important what this just said as a result of what I'm about to go next. Let's go here. Okay, so we know that Providence Patriarch was either left up for the king, father of the nation, or it was left up to the chancellor, i.e. Lord Chancellor, but somehow this authority has transferred to the Attorney General. Okay, and the Attorney General is not the judiciary. He's an executive officer, but he does not work for the judiciary. He's an officer of the court who brings matters before the judiciary as established by the king who put him in that position. But somehow the Attorney General has forgot this lesson, but he's about to get a clear awakening. Let's see Title 15 of the United States Code and see how they transfer Providence Patriarch from the crown, the king, Lord Chancellor, the Chancery Court to the state Attorney General. And if that is the case, then he should be defending us based upon what we call biases, defamation, etc. Okay? Lebelli slander. Parens patriae, monetary damages, and prejudgment interest. Everyone see this. Section C. No, not Section C. Right here. Section 1. Any attorney general of a state may bring a civil action in the name of such a state. We know the state is the body of politics at parens patriae on behalf of a natural person. Now we know the people, notice the natural person, okay? Because we know natural person can either be a naturalized citizen, misnomer as a national by way of Title 8 United States Code Section 1401, which then becomes a resident of the state in which they reside. And we know the word state means polity. We know that Article 10, the 10th Amendment clearly says that powers not delegated to the federal government are reserved for the states, respectively, or for the people, okay? Persons under the definition as defined are not the people, because people must have an ethnicity, a nationality, a genealogy, ancestry. A naturalized person does not, okay? So that meant that the Attorney General is acting on behalf of their residents, which they're now called natural persons, as described on Title 8 United States Code 1401, which becomes naturalized citizen, which in turn have the protection as rendered by the Attorney General. We see this in the federal level, and we see it on the state level. Let's look at it. Title A, Administration of Civil and Criminal Justice, Civil Action for Bias Crimes of Victims as a result of gender, expression, national origin, ethnicity, okay? If you're a resident, you ain't got to worry about national origin, you ain't worry about ethnicity, you ain't got to worry about gender identity, because you are a corporation, okay? Which is not necessarily a bad thing, okay? But you must understand corporate law. As said in Section C, the Attorney General as parens patriae may initiate a cause of action against any person who violates subsection A of this section on behalf of any person or persons who have sustained injury to persons or property as a result of the commission of a civil offense. That only deals with those citizens that were citizens of the United States under Article 8 United States Code Section 1401, which is a naturalized citizen, which is not a national because you're not construed to ancestry, okay? Which is a different type of due process of law in regards to your estate, which is protected by law, which we're going to go to now in regards to what the Attorney General should be protecting as defined in this case law. We're about to go to, and this case law is called Fountain versus Ravenel, an 1854 case. Very important, my brothers and sisters. Check it out. In closing, (1854). All right, let's see who has the power of parens patriae. Let's see who has the power of advocating on behalf of an estate that was made based upon charity. Okay, let's see who has the authority to do so that originated from the origin from the church. Okay, the bequest under consideration was intended to be a charity. Now we already talked about what charity is. All right, we know when them outhouses were put up by King Atherton, he had to acquire the land first to put him there, okay? So his first interest was the land, and that was based upon how he would convey it to the beneficiaries under the auspices of the trustees, okay? Reserved by Statute 61-28, right stated under the Articles of Incorporation, parts of right? State under the charge of Great Britain, safe from appeal. An act to incorporate trustees for religious property held in corporations in place thereof. So corporations are holding the property of religious corporations that originated from the charters, because we know all charters derive their power from a sovereign grant, and that's usually based upon the certificate of a corporation and the state where they reside, where the entity or the corporation came into existence. Okay, so it said to bequest under consideration was intended to be a charity. The donor, having entire confidence in his executors, substituted their judgment for his own, meaning that he allowed them to make the judgment, to make the call on how it would be in the best interest of the beneficiary. Okay, all right. They or the survivor of them was to designate such object of his charity in the two states as would be most beneficial to mankind. So we're talking about a conveyance from the grantor to the trustee that is charitable. All right, and we don't know charity going to charitable organization, which is a corporation. We know that stuff started in England. Okay, based upon uh, uh, actions of donating and the entire confidence and the execution based upon that confidence, based upon the judgment that was given to them under authority by the bequestment, was under their supervision. Okay, they or the survivor of them was the designated object of his charity in the two states as would be most beneficial to mankind, not one group of people, but to mankind. So we know we got to be talking about Adam and Eve. Okay, we know we got to be going back to Adam. Okay, but we just read based upon what Chief Justice said that when title deeds were given to Adam, when they sinned, they lost that right, and the deed fell into the hands of the devil. Okay. It was to be placed on the broadest foundation of human sympathy, not excluding the color, race. You hear that? Not excluding the color, race. It is no charity it is no charity to give to a friend. In the book, it is said the thing given becomes a charity where the uncertainty of the recipient begins. You hear that? A thing becomes charity where the uncertainty of the recipient begins. That means that the beneficiary or the recipient don't even know he's coming into that possession. That's our situation. We don't know that we now are coming to the possession of an inheritance that was under the authority and overseership of those trustees, which broke the agreement of the trust. Okay? One second. How about that? All right. So it said it was to be placed on the broadest foundation of human sympathy, not excluding the color, race. It is no charity to give to a friend. In the book, it is said that Thanksgiving becomes charity where the uncertainty of the recipient begins. This is beautifully This is beautifully illustrated in the Jewish law, okay? Which required the sheep be left in the field for the needy and the passing stranger, okay? So they're talking not to Jews, but they're talking about Israelite, but it's in Jewish law. It may be admitted that this bequest will be executed in England. Did you hear that? So they're talking about Jewish law in regard to the bequestment and they gave an example of the sheaf being left in the field for the needy and passing stranger based upon the charity, which means coming to possession and not realizing that the possession was actually there. Okay? That's a promise. Okay? That's a trust. That's an agreement. It may be admitted that this bequest would be executed in England. Where else? Nowhere else but England. A charity rarely, if ever, fails in that country. Did you hear that? Did you hear that? The only question there is whether it should be administered by the chancellor and the exercise of its ordinary jurisdiction or under the signed manual of who? The crown. That means the signature, y'all. That means the signature. Thus, furnished with the judicial and prerogative power, the intent of the testator, however vaguely and remotely expressed, if it be construed into a charity, effect is generally given to it. It is true, this is not always done in the spirit of the donor. For sectarian prejudices or the arbitrary will of the king's instrument sometimes pay little or no regard to the express will of the testator, which is the case in point. In Willer versus Smith, this court said, when this country achieved its independence, the prerogative crowns developed upon the people of the states, and this power still remains with them except so far as they have delegated a portion of it to the federal government. That is the 10th Amendment right there. The sovereign will is made known to us by legislative enactment. The state as a sovereign is the provence patriarch. When we're saying state, we're saying body of politics, and we know that the body of politics, i.e. the state, is ran by its officers, and with the attorney general is an officer, we know that the chancellor is an officer, we know that all the judges are officers, as well as the legislative makers, okay? There can be no doubt that the decisions have been made in this country on the subject of charities under the influence of English decrees without carefully discriminating whether they resulted from the ordinary exercise of chancery power or the prerogatives of the crown. Y'all better listen. The courts of the United States cannot exercise any equity. So the federal level, you ain't getting no equity. All right? On the federal level, except those conferred by acts of Congress and those judicial powers with the High Court of Chancery in England acting under its judicial capacity as a court of equity possessed and exercised at the time of the formation of the United States Constitution. Did y'all hear that? Did you hear that? The courts of the United States cannot exercise any equity powers except those conferred by the acts of Congress and those judicial powers which the High Court of Chancery in England, acting under its judicial capacity as the court of equity, possessed and exercised at the time of the formation of the Constitution of the United States. Powers not judicial exercised by the Chancellor merely as a representative of the sovereign and by virtue of the king's prerogative as provence patriarch are not possessed by the circuit courts. Did y'all hear that? They are not possessed by the district court. This is why they did not get the injunction that they wanted, okay? That's a matter for chancery, okay? That's a matter for chancery. That's why that matter was left for the individual states and those other states that bring claim for remedy and injunction based upon their purport, all right? But as the Court of Chancery also proceed in many, although not in all cases of charity, by original bills, as well as by commissions under the statutes of Elizabeth. The jurisdiction has become mixed in practice. That is to say that the jurisdiction of bringing information in the name of the Attorney General has been mixed with the jurisdiction given to the Chancellor by statute. Do y'all see that? They have intermingled the roles of the Chancellor that was under the authority of the King to the role of the Attorney General, which was appointed by the governor. And the governor was actually the Vice Chancellor, okay? The governor was actually the vice chancellor. We can go to NRA chancellor for that. Let's look at it real quick. In closing, you can't make this stuff up. It is sometimes said that the governor appoints the Associate Justice of the Supreme Court, and as the office of Vice Chancellor is created solely by an act of legislature, therefore the legislature can designate the appointing power. But this is fallaciousness, as will hereafter appear, as much as it may be desired that the appointing power be lodged in the governor by and with the advice and consent of the Senate, and will require a constitutional amendment to accomplish it. The reason why the governor appoints the Justice of the Supreme Court is in the Constitution of 1844, which requires it. It provides in Article 7, Section 2, Paragraph 1, that the governor shall appoint by and with the advice and consent of the Senate, the Chancellor. Did y'all hear that? The Chancellor. So in closing, let's go back to the case. So that is to say, so that is not always easy to ascertain in what case he acts. Let me read that part again. It says, but as the Court of Chancery may also proceed in many, although not in all cases of charity by original bill, as well as by commission under the Statute of Elizabeth, the jurisdiction has become mixed in practice. That is to say, the jurisdiction of bringing information in the name of the Attorney General has been mixed with the jurisdiction given to the Chancellor by the statute. So the only thing the Attorney General is to present information, to prosecute, all right, not to judge. So that is to say, now always easy to ascertain in what cases he acts as a judge, administering the common duties of a court of equity, and in what cases he acts as a mere delegate of the crown, administering its peculiar duties and prerogatives. Okay? And again, there is a distinction between cases of charity where the chancellor is to act in the court of chancery and cases where the charity is to be administered by the king, by his signed manual. But in practice, the cases have often been confounded for similar causes. It is a principle in England that the king prevents patriarch and enforces public charities where no other person is entrusted with the right. Where there is no trustee, the king by his Lord Chancellor administers the trust as the keeper of the king's consciousness. And it is not important whether the chancellor acts as a special delegate of the crown or the king acts under the signed manual, his discretion being guided by the chancellor. Okay? Everyone sees that. So we understand how important it is in order to receive equity based upon the trust that we have in the law, because we know equity is governed by the law, and we should trust in the law. And the one is put in head of the trust, i.e. called law, is the keeper of the king's consciousness, which is called the Lord Chancellor. As we can see, as stated by Chief Justice Tutu of the from Ghana, and I'll close out on that. We're gonna close out on that. Once again, God was the settler, and we know when you say God was the settler, that's trust law, all right? Settler, truster, grantor, the same thing. So Chief Justice apparently associated God's covenant with Adam and Eve with trust law, all right? Based upon the grantor, the trustees, and the beneficiary, okay? And we know that the way it's conveyed is through two ways: lottery of season and lottery of law. Lottery of law is the operation of law, and lottery of deed is the recording based upon the law, so that if it's attested, that it can be proved. This is why when you talk about Jesus coming in the cloud, he came to remove the cloud, the cloudy title off the land. All right? So in closing, God was the settler who created the earth for man as beneficiary to dominate in control. However, when Adam sinned, the authority, the title deed passed into the devil as the trustee. Damage was the only remedy that could be given by the common law courts. Many wrongs could not be adequately compensated. Sacrifice to God under the Old Testament were not enough to redeem man from sin. The blood of animal was not potent and efficacious, if I pronounce that wrong, efficacious enough. Pardon myself for pronouncing that word wrong. For it's not possible that the blood of bulls and goats could take away sin. Hebrews 10 verses 4. Rigidity. The slightest mistake one made in the common law courts rendered his or her entire action incompetent. Every year the high priest had to go to the Holy of Holies, and sometimes if he himself had sinned, he lost his life. Hebrews 5 verses 1 through 3. No mercy in the sight of God. Uzzah mistakes the holding the ark of God for stumbling into his life. 2 Samuel 6, chapter 6, 6 to 7. Lot's wife looked back and turned into a pillar of salt. Genesis 19, verse 26. Note then the name of Lot's wife is not mentioned in the Bible, but in Jewish traditions she was called Edith or Adu. Languages used at the common law courts were Latin. Meanwhile, majority of the people were illiterate. The law was written on scrolls, and only the priest and the teacher of the law could read and understand. Deuteronomy 30, 2 Chronicles 17, 8 through 9, and 2 Chronicles 35, chapter 35, verse 3. Effect. Many people who were denied justice due to the rigorous nature of the common law, man found it difficult to appease God no matter the efforts he made, meaning that every time we go into these courtrooms and these judges decide our case, is left up to their discretion based upon what precedent they use to decide the case, because they come a dime a dozen. All right. So for all who have sinned and fall short of the glory of God, you are subject to the common law of England. All those who have found equity in God, equality, i.e. grace, that means that you are subject to the laws or the lords of chancery. Okay. When many people could not get the appropriate remedy for the common law courts, the king intervened. Intervention. Okay. Permissive intervention. It caused his Lord Chancellor to listen to the grievances and resolve them. Man's hopelessness made God to send Christ to come and die for us. John 3, verse 16. So Jesus was an interceder. He spoke on your behalf. He was an advocate. He was a lawyer. He did things pro bono. He was a public defender. Okay? So take your cross and do what he did. Become a public defender. Who was the Lord Chancellor and why was he chosen by the king? This is going to be in closing. The Lord Chancellor was a priest or a bishop. As a member of the church, he was hereto the custodian of the king's royal seal, the one you see right behind me. He had been in the system for long, but because he did not preside as a judge, he was now known to the people. Why? Because they were in the church. That's why you don't know him. He was actually the one in charge of the court system, and the king thought he was better positioned to know the challenges of the court system. Okay? Very, very, very important. The chancellor was there throughout the operation of the common law, but was not known by the people as a judge. So you know about many other things, Levite, priest, magistrate, etc. But nowadays, they're called chancellor. The imperfection of the common law system led to the intervention of the chancellor with equity. That meant that in order for you to get equality, you must go to a court of chancery. Similarly, because the sacrifice of bull, goats, and other animals was not enough to save men, Christ had to intervene with grace. All right? Is there anything else left up in this article? Who was the chancellor? The chancellor was initially a priest, but with the time of the office, it became reserved for lawyers. Christ came to intercede for us as a high priest, Hebrews verses 7 through 26, but he should return as a judge to apply the law. You hear that, brothers and sisters? Nature of the chancellor's decision, morality, grace, other than the rigidity of the common law. You hear that? At equity, the language used was vernacular, other than the Latin used in common law courts. Now we do not have to learn Hebrew or Aramaic. to be able to talk to God. We can talk directly to him, and that's speaking English. I think that's enough. Let's see. That is enough. So with that, please understand how important it is to understand equity, equality, charity, and whatever you're doing, okay? But it must be functioning under the authority that charity was exemplified. And we know that goes back to the church, okay? So with that, I'm going to greet you as I always greeted you, and that's in peace and love. Thank you all for attending. Like, share, subscribe. All donations, please send them to the website as well as uh, the methods provided. I love you all. Hope you all enjoyed this lesson. Please do your research. Go in depth with it, like I have. Once again, it's just an honor to be able to elaborate more and more and more and bring the abstract to concrete that you can be standing on.